What is it?
They had to eat at lunch on your name.
I remember. She not like it.
Thank you. Please be seated. All right, we're back on the record. Thank you, Mr. Tian.
Thank you. Your Honor, again, if focus back to the scene when gunfire erupted, about 135 shots after Officer Diaz's first 4. You'll recall the testimony, Your Honor, but numerous officers left a cover position, not just Officer Brelo. The 3rd District Vice Officers, Demchek, Erek, O'Donnell, left cover, came down to the area where the Malibu was from the different directions they came. Brinkus and Salupo came up from the back, firing from this position to the rear passenger trunk side of the Malibu. Ereg and O'Donnell were coming down the grassy knoll, were firing through the passenger side windows of the Malibu. So that's the 2 2nd District Vice Officers, the 3 3rd District Vice Officers left cover, confronted. The 3 3rd District Vice Officers left cover, confronted. Other officers were taking cover back here. And you heard Officer Hummel, through tears, tell you in open court about the thoughts of feeling like being a coward, that many had that feeling. O'Donnell, she was either going to crawl up into her glove box or get out. She said she wasn't a coward. She came down to help. Demchek came to the rear. Sisnick got out, was still firing. Patrick and Moore in box, although they took cover at the side of the passenger side of 217, Your Honor, they came out to take shots which would have gone through the driver or passenger front windshield or through the driver's windshield. Box was fumbling with the shotgun. He left the cover position. Box couldn't remember how he got there. Sobolik, in his Garrity statement, Your Honor, he couldn't remember how he got over to the playground. But he knew he wound up there. And Officer Brelo couldn't remember, didn't deny, but had no recollection of the final moments where he was on the hood of the Malibu. And I ask you, what's the consequence of that? If Officer Brelo had recollected when he gave his statement that that was his position before he got the keys out, would he be saying that I had no legal justification then? He was firing from the trunk of 238 behind the light bar, which was flashing in his face with the siren going off, scared to death, detected movement, which is consistent with the strobe effect of those lights, which is consistent with the testimony of Dr. Michael and others, including Mr. Shaughnessy's disco dance examination of the state's lighting expert and the effects of strobe lights. At the end of the day, the state wants to argue that Officer Brelo had amnesia or didn't remember being on the hood of the Malibu. But at the end of the day, Your Honor, if he wanted to lie, he could have come up with a lot better account other than simply that. And that's what happens in these things. That's what all the experts have told you. No matter which psychobabble term they use, the reality of these experiences, and who better, Your Honor, to talk to you about that than Dr. Johnson, who is trained with the elite forces in the military, who gave you firsthand testimony of the real-life experiences and the disassociation the memory lapses, how the brain fills in what you think really happened. All those things happen. That stuff wasn't made up, whether or not he had an interview with Officer Brelo or whether or not he tested Officer Brelo. That came from his empirical experience, from talking to elite forces in the field, engaged in hand-to-hand combat that we entrust on dangerous missions to go overseas and fight for us. That's the experience that he told you about. And we're not malingering here. We're not trying to get a claim recognized for PTSD, Your Honor. And we're not making up a story here. What happened, happened. The casings are found where they're found. Officer Brelo has never denied what he did in this case. He's never tried to point the finger. It wasn't me. I wasn't on the Malibu. It was Officer so-and-so. Or it just wasn't me. So at the end of the day, he could have come up with, if we had to write a script for him, which we don't do, we could have come up with a lot better explanation than what he indicated. And he said what he said because no one tells people what to say. And that's, his version of events, Your Honor, is consistent with the findings of Dr. Johnson. You heard the testimony of Dr. Knoll, and at the end of the day, you know, his life experience, Your Honor, deals a lot with psychiatric clinic referral to mitigate the penalty or competency or sanity at the time of the act. Is he serious? Are we going to equate the death penalty defendants that come through your courtroom or some of the other cases that come before you with an officer who, in the line of duty, uses deadly force and is going through the mental trauma that he went through that was exhibited in his interview with Agent Soraya? We're equating Officer Brelo in that population of miscreants that Dr. Knoll interviews from time to time who are rapists, murderers, robbers, burglars. I think not. And he can point to a study all he wants. He couldn't answer Mr. Mack's questions about whether or not any officers were in that sample population with those statistics, but 90% of them did have some legitimate form of dissociation or memory loss. So in this particular case, Your Honor, it's not convenient amnesia. It's understandable how someone who is at death's doorstep seemingly and has to confront that blocks it out. How many examples have we had, Your Honor, where we've had the experience of watching President Obama pin medals on people that come back from overseas, where they took actions heroically to save others? They risked their lives to either grab a hand grenade or step on a landmine to save everyone else. How many examples do we have? I say countless. And all you have to do is Google it and you'll see the information there. It happens day in and day out. So I think the instinctive act that Officer Brelo engaged in this case was a selfless act, a fearless act by someone who was terrified and scared to death. And whether he'd react that way, Your Honor, 50 out of 50 times, the Lord knows. I'm sure all those officers on that scene would not be able to predict how they would have reacted to those events. And as Officer Sobolik told you, you can't train for this. This isn't, the Cleveland Browns running an off-tackle play or running a pass play with a couple different options. When the bullets are flying, some people stand and some people run for cover. Doesn't make them cowards, but that's a pretty horrifying reality, and that's a pretty horrifying choice one has to make. Officer Brelo did it, and he reacted instinctively. And why does a person who has values, why does a person that believes in things shoot 49 times? Your Honor, I respectfully submit to you that to ask the question is to answer it. And it could be summed up in one word: fear. Officer Brelo was scared to death because of the reality that presented itself that began 20 minutes prior to that and led up to the events in that parking lot. And he was not the only one. Officer Ehrig was scared shitless. Officer Box was trembling with a shotgun, his sweaty palms, he couldn't even hold it. Officer Sobolik told you that the officer he was supposed to work with, the next day Officer Dooley was saying, "Why are you shaking?" His hands were all sweaty. So these are some of the real-life experiences that those officers felt on scene, Your Honor, and a person that we respect and have a lot of admiration for, this gentleman right here, Agent Soraya, who did his job, came into court and told the truth. You didn't have to look at him and figure, does he know what he's talking about? He told you about how over half of the officers who were interviewed all displayed emotion. Many of them cried. And unfortunately for you, we haven't had the opportunity to show that to you in this particular case. I wish you had the opportunity to see that. It's pretty gripping. And I was there for all their interviews, as the state has pointed out time and time again. And you can't fake that stuff, Your Honor. You can't fake the emotion. Brelo did not go to the Screen Actors Guild and get training. When he went for his interview with Agent Soraya and Sergeant Gardner from East Cleveland, he didn't cry on cue. The transcript, and we cross-examined Agent Soraya on that, was replete with references to, "Are you okay? Do we need to take a break?" Officer Brelo, Your Honor, did not assert any privilege. He came in there like all the other officers. We cooperated, and they told Agent Soraya what happened, and they answered the questions that were posed. And yes, he did talk about lighting. It's in the transcript. It's an answer to questions that Officer Kindness from the union asked. He did indicate how he was terrified. He did indicate, Your Honor, why he shot. He fired his weapon not because of the color of their skin, not because he was upset with them that they put the police on a pursuit. He fired because he was terrified. He thought the occupants of the Malibu were shooting at him. And that's what he felt when he was shooting over the light bar of 238. He was terrified. He was shooting at the people who he felt were shooting at him. Whether he mistakenly believed them to have a weapon or whether he mistakenly perceived movement where none existed because they were dead already. And he continued to fire his weapon, Your Honor, till he believed the threat was over and until he recalled that he was then taking the keys out of the ignition, putting the car in park, and then putting the keys on the windshield. And Detective Diaz told you that Detective Raynard was the first of the two on the scene, and Detective Raynard in the police report has the Malibu off and the keys on the windshield, like Officer Brelo said. The evidence is clear. Officer Brelo reasonably perceived that he was being shot at by the occupants of that Malibu, and he continued to return the gunfire. And there's absolutely no evidence before you, Your Honor, that all the other officers stopped shooting because the threat was over. There's no evidence before you that all the other officers stopped shooting because they saw Officer Brelo. It's to the contrary. We know that Officer Moore, because of the number of rounds in her Glock, reloaded and shot one other round from her other clip. We know that Officer Rinkus had fired his entire 13 rounds and it got another magazine from another officer. We know that other officers were taking cover, and they were taking cover because of all the gunfire. And we know that Cindy Moore wanted the shotgun. So the threat wasn't over, and it wasn't perceived to be over, and Sobolik told you that, Your Honor, when he came into court. He raised his right hand, and he swore that after he fired his 4 rounds from the 2 locations that he testified to, and after he saw an officer standing on the hood, he came around and was trying to fire again. So what does that tell us about what Officer Sobolik perceived? That the threat truly was not over. He was trying to fire again. And in spite of how the state wants to run from their expert reports, The court will recall the cross-examination by Mr. Mack of Mr. Marr and the mental gymnastics we had to go through, but at the end of the day, he could not run for the spoken and printed word in his report. And the court will recall how he characterized those 3 additional shots. It was also consistent with gunfire. That was his language. And I didn't hear it in their opening close, but they also had another expert by the name of Mr. Beck. And Mr. Beck was pretty unequivocal about 3 other gunshots beginning after the 4th shot in that last series. So from that expert and our expert, Mr. Stutzman, we have 3 other gunshots in that last series. And again, Your Honor, I characterize it as a series only with the benefit of 20/20 hindsight as we've listened to that. The officers on scene did not perceive a pause or a break. It was one continuous round of gunfire. So we know that, in fact, the shooting wasn't over. There were 1, 2, or 3 other officers firing besides Officer Brelo. Officer Sobolik was trying to get another shot. And other officers were taking cover. We know that for a fact. And we also know for a fact that the state has not presented evidence that proves how many of the last 15 fired by Officer Brelo were fired while on the trunk of 238 or while on the hood of the Malibu. However one wants to break those up. There's no direct proof, there's no direct evidence of that. And we also know that Mr. Casares, Your Honor, besides having issues with leaving one's feet, testified unequivocally that if Officer Brelo fired all of his rounds from behind the rear, behind the trunk of 238, they would have been objectively reasonable. Not my words, Your Honor, his. And that's what he said. So we go from all those shots being objectively reasonable in terms of the number of shots fired and the reasonable perception that those would have been justified, all of a sudden because Officer Brelo in that setting made an instinctive judgment to jump up on the trunk and then onto the hood, that he went from being justified to being not justified. I submit to you that that's a distinction without a difference, and I submit to you that this whole notion about officer safety is completely different from the issue of whether or not illegal force was used. The fact that Officer Brelo made a split-second decision and endangered his life is not evidence whatsoever that his use of force was illegal. Those other officers also exposed themselves, Your Honor, when they converged on that car. Those are not criminal acts. Those are acts that these officers took under the heat of gunfire. And no matter how much we try to parse it, that's what happened. And the last thing that Officer Brelo was concerned about, or I think anyone else in his position, was how many cars were in the back by the driveway when they're dealing with gunfire that sounded like a machine gun, according to Officer Hummel. So, Your Honor, no matter how we argue it back and forth, that's the reality of what happened there. And yes, in fact, when we did our little field trip in the warehouse, when you look at those lights, even in that condition, and you focus on those lights, it's blinding. And Officer Soraya acknowledged that when he was on the stand about backlighting and the strobe effect. And if you don't believe it, go out there with a lot of cars and watch it at nighttime, and you'll see. And look at not only that, but also turn on the sirens and see how your senses are when you're reacting at that time. And the law says that you have to consider the totality of the circumstances, not some laboratory or not some after-the-fact recreation that has no reality to it. Not a portrayal of someone standing on a car with white or beige pants, not navy blue police garb. And not with gunshots going off, Your Honor, and not with sirens going on, and not with all those flashing lights. And again, we'll come to it, but the Court of Appeals decision in the White case makes reference to Mr. Katsar's testimony about the effects of the sirens and the lights in that case, which are equally applicable to what happened in this case. Your Honor, I ask you to call the testimony of Dr. Michael on the whole aspect of vision, how it's affected with the eyes, but also the brain, the action-reaction principle, the influence of aiming and how that has an adverse effect on your peripheral vision, how when you fire there's the orange ring, how that affects your focus and concentration, and also when you have tunnel vision, how that in essence inhibits one from having much of a peripheral vision. The examples about the veiling glare and the deers in the headlights, it's all there, Your Honor, and it's all straightforward. Your Honor, I ask you to take into account, again, when you look at these CAD reports and the timeline, the pop can broadcast from Officer Fairchild came prior to subsequent broadcast about it looks like the passenger's reloading, the passenger's reaching for something. It wasn't over then. Detective Fairchild told you that as well. And all those things, Your Honor, had absolutely no bearing whatsoever on any of the 12 officers losing their probable cause and justification for firing 90-some shots. I ask you to consider, Your Honor, when you review the issue of causation, that our testimony was direct and straightforward. But you have numerous shots in this case coming from the rear passenger side of the Malibu. You have Officer Rinkus firing, his shell casings are there, Your Honor. 13-some shots. Some casings are on the sidewalk area. Again, the point of view from that standpoint is through either the back windshield or the passenger back window or the passenger window itself. You also have Salupo firing 2 shots from that perspective. You have Ehrig and O'Donnell firing 6 shots by Ehrig and O'Donnell firing 12 shots. Again, Your Honor, numerous gunshots that would explain, as Mr. Martini opined, and as Dr. Rowe opined, and as Dr. Posey opined, that's set forth in Mr. Martinelli's report, that the fatal headshots to the driver and the passenger came from that street, at the ground level orientation, and they're coming from this angle. And I ask you to compare it to the tortured construct of trying to account for the headshot wounds for the driver coming through the windshield that you observed when Dr. Weens testified. And forgive me, but I represent a client, and I'll just put it straightforward. If you had the occasion to treat with Dr. Weens in the hospital, would you not go and get a second opinion very quickly? I respectfully submit to you that Dr. Rowe was very learned and very credible in her account, and that there was a line crossed between educating and informing as an expert to being used as an advocate. And I think that unfolded in front of our very eyes.
And she's dead already. She only does autopsies. So.
Well, in a different setting.
But I do get your point.
And, Your Honor, you'll also, I hope, note that the defense in this case didn't tell any physician to make something pre or post mortem, not peri-mortem. There's only one side of the courtroom that did that in this case. And they're not doctors either. You'll recall the testimony of those medical experts, Your Honor, that those headshots were instantly fatal, and because of that, and because of the position of the bodies, it was opined that those headshots were sustained by the decedents prior to the last series of elevated shots by Officer Brelo. That is the testimony, Your Honor. It has not been refuted by expert testimony to the contrary based on reasonable medical or scientific certainty. And that's a fact. And we presented Mr. Martini and Dr. Rowe, and now you have in evidence Mr. Martini's report. Your Honor, I wanted to, if I can, turn to just a couple of these cases. We can start with State versus White, the appellate decision in 2013. Your Honor, you have demonstrated that you are scholarly in your approach to cases, even at the trial court level. So I respectfully direct your attention to the appellate decision in the White case, because I believe that it, in a very scholarly way, sets forth the relevant case law that we respectfully submit you must consider in this case. But I wanted to make reference to the testimony of Mr. Katsaris on the issue of lighting and the sirens. If you recall, this is the case, Your Honor, where Officer White shot the person on the motorcycle. And here we have a summary objection. This is from an appellate court decision.
Hold on. Based on?
Judge, you don't get me. Never mind.
Well, let me ask you this, Mr. Gutierrez. Is there something in my deliberations on this case that prevents me from looking at case precedent?
Absolutely not, Judge.
Kind of in the manner of, I guess you'd call it analogous to jury instructions in a jury trial?
Absolutely not, Your Honor. I think fact should do that.
The reason I ask is I think that I understand your objection, but the point is I can and frankly probably will read this case again anyway. But I recognize that this testimony is not in evidence by this witness. I understand that.
I'll withdraw, Judge. Thank you.
Your Honor, if I may, on section 46 of the opinion, page 23, on the subject of the impact of sirens and lighting, Katsaris maintained that Officer White violated one of the tenets of traffic stops by not turning off his cruiser siren before getting out and shouting orders. This is necessary so people in the vicinity of the officer's vehicle can hear him. The added blare from Sergeant's siren, Your Honor, that was the other officer that responded on scene, only worsened McCloskey's ability to hear White. So again, Your Honor, this is common sense, but for some reason, maybe I'm just too defensive, but I feel that the arguments that we've maintained have been given the back of one's hand as being not relevant. But certainly with two cars, Mr. Katsaris pointed out that the combined effect of the wall of light and the high decibel sirens likely so disoriented McCloskey that he could not see White and would barely hear his commands. Again, Your Honor, we think that in this particular case, given the lengthy pursuit and officers driving behind all the cars in front of them, looking at the veiling glare, and then coming to the scene here, that it's understandable that all that lighting and the lighting at the scene with the gunfire had a disorienting effect, just as Mr. Katsaris testified in that particular case, coupled with all the loud noise at the scene. And again, Your Honor, the appellate court in White held that because in prosecutions of law enforcement officials for using illegal force, the law borrows from the federal case law, the court noted that when a federal use of force law applies to the prosecution of a police officer for alleged misuse of force on duty, then all of its doctrines, standards, and derivative rules apply to the extent their use is supported by the evidence and is consistent with the nature of the crime. And that's where we then get into a whole discussion about Garner and how there's two circumstances or conditions that limit an officer's authority to use gunfire, and that is the threat perception cases, and then the other cases, Your Honor, are the cases where someone is fleeing after they have committed a serious offense and the officers respond and use deadly force. And in the footnote, that's where we're talking about the second set of circumstances that come up in these cases. And again, the Court of Appeals made clear that the standard that must be used is the U.S. Supreme Court law that's set forth in Garner, and that was, I think, clearly set forth by the Ohio Supreme Court decision on that point. So the federal law is that a serious and imminent threat to the officer's safety will permit him to respond with gunfire. Thus, reasonable threat perception is a minimum requirement before deadly force may be used. And they then get into whether or not someone's armed or not. In deadly force cases involving both armed and unarmed suspects, courts have accepted the action-reaction principle that you've heard about in this case, Your Honor, on facts justifying the officer's anticipatory use of his weapon to protect himself. In other words, a nascent threat can be sufficient. It need not materialize to the point of harm. Use of deadly force is presumptively reasonable when the officer could reasonably have interpreted the suspect's movement as reaching for a weapon. In other words, an officer does not have to wait until a gun is pointed before acting. An officer need not actually detect the presence of an object in the suspect's hand before firing on him. The critical point is precisely that the suspect was threatening the lives of the officers. The Fourth Amendment does not require police officers to wait until a suspect shoots to affirm a serious threat of harm. And again, Your Honor, these are principles of law from our federal courts, not some police officer making up some phony excuse. Officers need not be absolutely sure of the suspect's intent to cause them harm. The Constitution does not require that certitude preceding the act of self-preservation. Rather, it is the perceived threat of attack by a suspect, apart from the actual attack, to which the officer may respond preemptively. If his perceptions were objectively reasonable, he incurs no liability, even if no weapon was seen, or the suspect was later found to be unarmed, or if what the officer mistook for a weapon was something innocuous. And then it goes through the different cases where officers were found to have acted reasonably, even in the absence of a weapon. And the courts have also pointed out that officers are trained to recognize certain behaviors and body language as danger cues. These include attempts to evade the officer, furtive gestures, glances, sudden turns, and the ignoring of commands, such as orders to show one's hands. And because such encounters often occur at night, this limits vision significantly and enhances risk to both the officer and the suspect. And again, it goes through the cited cases, Your Honor, which I'm sure you'll review, and I'm sure you probably already have, documenting court determinations on these issues. And the footnote talks about the officers commonly infer threats from the way a suspect moves based on the immediate perceptions and street experience. It's been highlighted in other state courts. And again, in I think a famous quote, and I think it has application in this case, it is equally apparent that the law-abiding persons do not normally step back while reaching to the rear of the waistband with both hands to where such a weapon might be carried. Although such action may be consistent with innocuous or innocent behavior, it would be unrealistic to require the officer to assume the risk that the suspect's conduct was in fact innocuous or innocent. It would indeed be absurd to suggest that a police officer has to await the glint of steel before he can act to preserve his safety. Your Honor, the testimony about what normal people do in terms of driving a car, I don't think normal people turn around in the front passenger seat, get on your knees, and and extend in a two-handed position like you're firing a weapon at police officers. Police officers aren't crazy when they interpret that as danger and someone's pointing a gun at them at nighttime. Not even taking into account the prior broadcast of a weapon being discharged. The footnote 15 also indicates that nothing in Gardner contradicts the cases in which unarmed suspects have been shot if the officer's threat perception was found objectively reasonable. In the reasonable threat perception cases, all the signs were to the contrary. That the suspect was found to be unarmed afterwards was, in the words of the court, irrelevant. And then it talks about the grand factors that we've heard time and time again. The court pointed out that this is a non-exhaustive list in the calculus of what is reasonable, and that there are other factors that the court may look at, including whether it happened at night, the suspect's demeanor, whether they were intoxicated or non-compliant, whether they appear to be violent or dangerous, the duration of the confrontation, whether it occurs during a chase or an arrest, the possibility that the suspect may be armed, and the number of suspects with whom the officer must contend, and some of the constraints on evaluating the reasonableness, Your Honor. And the Grand Court cautioned when evaluating the law enforcement conduct that you must give some deference to the law enforcement perspective. In another famous landmark quote, Your Honor, not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment. We must avoid substituting our personal notions of proper police procedure for the instantaneous decision of the officer at the scene. We must never allow the theoretical, sanitized world of our imagination to replace the dangerous and complex world that police face every day. What constitutes reasonable action may seem quite different to someone facing a possible assailant than to someone analyzing the question at leisure. Again, the court notes that in evaluating reasonableness, some leeway must be given the officer for on-scene judgments made during the uncertainty of a confrontational encounter. Unlike judges and juries, officers on the beat are not afforded the luxury of armchair reflection. And then there's case law that's cited relative to the trier of fact and the required perspective of a reasonable officer on the scene, that the facts must be filtered through the lens of the officer's perception at the time of the incident. We humbly submit, Your Honor, that as you deliberate in this case, you must look at the scene through the lens of the eyes of the officers as they were dealing with these bullets flying on November 29, 2012. Facts learned or discovered later, like maybe no weapon found in the car, and maybe if it was blocked off some kind of way, or maybe how many police officers we had. These facts learned or discovered later and actions taken afterward are irrelevant in this review, even if they would be relevant for some other purpose. The use of experts. You took judicial notice of the difference between the Ohio Rules of Evidence and the Federal Rules of Evidence, Your Honor. The Court of Appeals in White went forth the case law on how expert opinion goes beyond what's appropriate. Graham's prohibition simply extends to the testimony of even the most, or whatever, I always have a hard time pronouncing that, erudite police procedure consultant when it comes into the prohibitive territory of second-guessing and armchair reflection. This includes comparative speculations couched in backward-looking terms about what the officer could have or might have done differently, like maybe not leaving the ground, and whether he should have employed alternative or lesser means of force or different tactics. If we consider the expert's assertions regarding the failure to use pepper spray and other tactical measures, we would be evaluating the officer's conduct from 20/20 perspective of hindsight rather than the perspective of an officer making split-second judgments on the scene. And the court then went into inappropriate conclusions that experts draw, and whether something is objectively reasonable or not is held inadmissible. We've had a plethora of testimony in this case on opinions that matters were not objectively reasonable. expert testimony the force was not justified, was held inadmissible. With relaxed consideration in this case, Your Honor, because it's a bench trial and our respect for you to ferret through all this testimony. But that's the law that the Court of Appeals of the State Appellate Court in Ohio has cataloged in its 100-some page opinion. The jury need no help in deciding whether the officer acted reasonably in shooting the suspect. And then it goes to reasonable but mistaken belief. And we've heard that before, Your Honor, in this landmark Saucier case on the issue of qualified immunity, sets forth all that law. If the officer's mistake is reasonable, immunity attaches regardless of whether the officer's error is a mistake of fact, a mistake of law, or a mistake based on mixed questions of law and fact. I think that was the last part of that decision. Again, Your Honor, the case goes on talking about the ultimate issues, whether or not the officer had a reasonable perceived imminent threat. I'm sure you'll review that in your deliberations. We'll go to the Supreme Court decision real quick, please. The Ohio Supreme Court in White. Your Honor, in your journal entry on, in your ruling on the Rule 29 motion in this case, I think you very succinctly extracted the holding from our Ohio Supreme Court in White that the applicable law is the Gardner decision, and that is whether the officer had probable cause to believe that the suspect posed a threat of serious physical harm either to the officer or to others. And the court gave two examples. That goes into the threat cases and then also the escape cases. It goes through the landmark quote about 20/20 hindsight. It also makes reference to the Plumhoff case. That was an escape case that Rickard's flight posed a grave public safety risk. And here is in Scott, the police acted reasonably in using deadly force to end the risk. Your Honor, in terms of jury instructions, that's not going to apply in this particular case, but your research on the law will point you to the correct standard. But the importance I wanted to respectfully direct your attention to was when the majority opinion notes that even though a correct principle of law is stated, it doesn't mean that that instruction should be given to the jury, because sometimes it can be confusing or misleading. And that's what some of the language that I have highlighted here talks about, because the court in White, the Ohio Supreme Court in White, was speaking of the Graham test of reasonableness really isn't the standard. The standard is the Gardner decision. So we require the jury instruction to present a correct, pertinent statement of the law that's appropriate to the facts, but there is a limit, and no purpose is served, for instance, by requiring courts to present redundant jury instructions or instructions that are so similar to other instructions being presented as to be confusing. Here it is not disputed that White used deadly force in the line of duty, and therefore the jury charge should have been tailored to instruct the jury on when a police officer is justified in using deadly force. Because a police officer's justification to use deadly force is limited by the Fourth Amendment, the appropriate instruction on deadly force is taken from Graham. And Graham establishes that where the officer has probable cause to believe that the suspect posed a threat of serious physical harm either to the officer or others, the officer does not act unreasonably by using deadly force. The test for deadly force is not so imprecise, and that's after the court made reference to Graham and the Graham. Gardner defines a very circumstance to be considered in a deadly force case such as this. That is where there is probable cause for a police officer to believe that the suspect posed a threat of serious physical harm to the officer or others. The description of objectively reasonable under the circumstances here is vague to the point of misdirection. Those are the words of our Ohio Supreme Court, Your Honor. And importantly, not every statement of law related to reasonableness is an appropriate instruction in every deadly or excessive force case. The relevant principle for jury instructions is not one of abstract correctness, but is whether an instruction, even if a correct statement of law, is potentially misleading. Nothing in Graham modified the principle of law that Gardner had articulated. A police officer acts reasonably in using deadly force when the officer has a reasonable belief that the suspect poses a threat of serious physical harm or death to the officer or to others. If we go to pull off real quick. And Your Honor, right before the grand jury indictment was returned in this case, the United States Supreme Court came down with a plumb-off decision, which was another pursuit case. And the court's ruling was very succinct at the beginning. We reverse and hold that the officers did not violate the Fourth Amendment. In other words, their use of force was reasonable. In the alternative, we conclude that the officers were entitled to qualified immunity because they violated no clearly established law. And in that particular case, shots were fired at a vehicle after a pursuit, not as lengthy as the case before you. Your Honor, there is, I believe it's appropriate. I have the video here. I won't play it. I don't want to get Mr. Gutierrez too worked up here. But I think it's appropriate for the court when it reviews decisional law. There is a video of the pursuit and the shooting in the Plumhoff case that's online, and you can view what was, it's called documentingreality.com, and the pursuit's there. You want me to play it, Jim, or no? You going to object? Yes. Okay, they're going to object. I've had a long time, so we'll ask the court to look at that. And I think the point I wanted to make, Your Honor, is that in the Plumhoff case, the officers clearly shot at this car after it was cornered, and the driver put it into reverse, spun around, and drove off, and you have officers following shooting. The U.S. Supreme Court held that that was not unreasonable, unlawful force. And the court rejected the argument that the petitioners acted unreasonably in firing a total of 15 shots. It stands to reason that if police officers are justified in firing at a suspect in order to end a severe threat to public safety, the officers need not stop shooting until the threat has ended. As petitioners noted below, if lethal force is justified, officers are taught to keep shooting until the threat is over. And again, Your Honor, you must look at that through the lens of the police officer in the circumstances that you find in this case. In arguing that too many shots were fired, respondent relies in part on the presence of Kelly Allen in the front seat of the car. But we do not think that this factor changes the calculus. Miss Allen was a passenger, Your Honor, in the front seat. She was killed by the police as well in this use of deadly force. The United States Supreme Court noted that, after all, it was Rickard, the driver, who put Allen in danger by fleeing and refusing to end the chase. And it would be perverse if his disregard for Allen's safety worked to his benefit. Under the circumstances presented in this case, we hold that the Fourth Amendment did not prohibit petitioners from using the deadly force that they employed to terminate the dangerous car chase that Rickard precipitated. If we can go to the Jones case, finally. Your Honor, I don't know if you recall, during the Rule 29 argument, Mr. Shaughnessy pointed your attention to the Jones versus Albertville, Alabama case that was decided October 28, 2014. It's a United States District Court opinion. And again, in that particular case, Your Honor, there's a few highlighted portions which we think are relevant, but one of them dealt with whether the threat was over, and in that case, the officers fired 13 shots through the windshield. Another one fired 15 rounds. And then there was a 7-second pause, and when the driver presented behind the steering wheel from a slumped position beforehand, The one officer fired twice, and the court held that that was not excessive force. Officer Maher began firing his pistol at Jones as soon as Schiff discharged all of the rounds in his weapon. He discharged 13 shots within 5 seconds and then paused. As Maher approached the truck on the driver's side with his weapon aimed at the cab, Jones suddenly sat up behind the steering wheel and Maher ripped off 2 more shots. That occurred a little more than 7 seconds after the end of Maher's initial volley. The engine of Jones's truck was still running, as we had in this case, Your Honor. Consequently, Maher opened the driver's door, reached into the truck, and removed the ignition key. Neither Schiff nor Maher had issued any verbal commands to Jones before discharging their weapons, a matter that Mr. Katsaris opined very strongly on this case. There's an expert opinion here, Your Honor, that the court dealt with, that Mr. Buskin. Here, Mr. Buskin's opinions as to the reasonableness of Officer Maher's actions will not assist the trier of fact because it is the role of the judge and not an expert witness to instruct the jury on the applicable principles of law. In other words, an expert may not merely tell the jury what result to reach, and a witness also may not testify to the legal implications of conduct. Instead, the court must be the jury's only source of law. Another part of this opinion, Your Honor, the court may note that this case was virtually indistinguishable from Plumhoff. But one of the issues in this case, Your Honor, was whether or not the officer that fired the last 2 shots after the 7 seconds, whether or not that officer should have known that that truck was disabled and was not going to drive forward or drive backwards. And the court responded, under the circumstances recorded by the officer's dash cameras, a reasonable officer could have concluded that Jones had transformed his truck into a deadly weapon and was attempting to crush Officer Schiff. Davis had used the automobile in a manner to give reasonable police probable cause to believe that it had become a deadly weapon with which Davis was armed. Just before Officer Maher fired his final shots, Jones sat up behind the wheel of the still running truck. His sudden movement could have been viewed as an attempt to regain control of the truck. Therefore, Officer Maher's reaction was reasonable. He was not required to wait and see whether Jones intended to back his truck into and over Officer Schiff's patrol car yet again, or to leave the scene and thereby evade arrest. And then the court then continued with the Scott case that I made reference to before. A reasonable officer at the scene, forced to make a split-second decision about whether he should shoot Jones, would have no way of knowing whether Jones intended or was able to resume his dangerous flight or to shift his truck into reverse in another attempt to crush Officer Schiff. As long as Jones was in the cab of his truck and behind the wheel with the motor running, he was capable of driving and thereby posed a risk to the public. There is no guarantee that the push bumper that the prosecutions or the plaintiffs in this case argued that the push bumper of the patrol car was attached to the truck of Mr. Jones. There's no guarantee that the push bumper would have remained attached to the patrol car if Jones had attempted to speed off, or that it would have remained intact and prevented Jones from backing his truck over the hood of Schiff's patrol car, possibly injuring or crushing him in the process. Under the circumstances at the moment when the shots were fired, all that a reasonable police officer could have concluded was that Jones was intent on resuming his flight, and that if he was allowed to do so, he would once again pose a deadly threat for others on the road. In order to end a severe threat to public safety, you need not stop shooting until the threat has ended. And then the court then dealt with this whole issue of verbal warnings, Your Honor. At the time Maher began firing his initial volley of shots, Jones' truck had just rolled off Officer Schiff's hood. At the time it would have taken Maher to give Jones a verbal command, Jones could have backed his truck over the hood of Schiff's patrol car a second time and seriously injured or killed him. Jones also could have driven away. So this whole bit about verbal commands in the context of that type of conduct was, I don't want to characterize the court's conduct because I'll go too far. I know you'll characterize it correctly, Your Honor. I've talked way too long, so I would just like to wrap up, Your Honor, by saying that about 37 years ago when I was in law school, in a legal philosophy and legal research and writing class, our professor quoted from a book called The Bramble Bush by legal philosopher Carl Llewellyn. And they were talking about the Socratic method and also talking about the idealism that some have in the law to the cynics. And there was also, I think, a reference to Charles Dickens, maybe where this quote came from, or someone else. But what I recall from it was the quote that always stuck with me, that the law, there was a debate going back and forth. The cynics were saying that the law is an ass, and the idealists were saying that the law is not an ass. Well, despite the ups and downs and the fighting and all the wrangling that goes around in courtrooms and 37 years of trying cases, I started off naive, and I've come through the sausage grinder at the end here, believing in the rule of law and judges like you doing what's right and finding what the facts are and applying the law. And my belief, notwithstanding all the fighting in October last, has not been shaken in one way, shape, or form. Thank you, Your Honor.
Thank you, Mr. D'Angelo. So that I don't have to interrupt, and we'll go right from who's going first, Mr. Gutierrez? Then I go right from Mr. Bell to Mr. Gutierrez. We'll take like 10 minutes, and then unless you far exceed your estimate, this will be our last break. So thank you. We're off the record.